and John Bair, who's going to visit with us about QSFs in the time of COVID. John has over 20 years of diverse experience in the settlement planning industry, in the civil justice community. He is the founder and CEO of Seventh Amendment Holdings. I like that name. A company that provides comprehensive settlement planning and management through its subsidiary companies, specifically Milestone Consulting and Monolith Advisors. John is located in Buffalo, New York. Over to you.
Great, thank you. Well, what an honor it is to be, part of this AAJ seminar. Never thought that we would be working remote with kids at home. Never thought that I would try to get myself a haircut. So there's definitely some different things happening. So happy to present today on what we think in our practice is just an all-around workhorse of a settlement tool that we've really been using for over 20 years. We like to think that the Qualified Settlement Fund is to settlement that depositions are to trial. It's your preparation phase, and if you're going to resolve a significant case, you really ought to be thinking about and talking to your expert about whether it makes sense to rely on a Qualified Settlement Fund. If I get the, it's something to think about. As we do over $1 billion worth of QSF administration on thousands of cases, a question for the bar and the judiciary and our arbitrators, neutrals, is has the Qualified Settlement Fund matured to the point, that it really it's the next generation of IOLTA or attorney trust account. Can it serve those many functions that are important, accounting, distribution, lien resolution, etc. Without a Qualified Settlement Fund, you can't separate the business interest between the attorney and the client, and that's a good thing in civil justice. The lawyer and the client are married at the hip during litigation, and they have a common interest in the pursuit of the litigation. But at settlement, that we know that dynamic changes significantly. And so one of the things that we think very useful about a Qualified Settlement Fund is that it cures that. Even though there is a separation, you can still rely on that. In planning settlements, there's always a time crunch. There always seems to be not enough time from when a case resolves and when the clients really need to start making decisions. And anybody that's gone through a catastrophic litigation knows that it's very difficult for their clients to process. They go through phases much like death, and from emotional trauma to just literally not being able to process. And so that time crunch nature of settlement planning, in my opinion, is inappropriate because you don't have to. And a lot of lawyers through the last 2 decades have tried to get everything finalized so that they can execute releases and collect. And so Qualified Settlement Fund certainly clarifies that as well. Talking about the benefits, it's time and the time value of money. Talking about the basics, creating a Qualified Settlement Fund, if you have some experience in mass torts, it is not just an animal or a beast of mass torts or multi-district litigation or state coordinated cases, although they are used prevalently in those types of the cases. They are equally as valuable in the individual PI case, a med-mal case, or a products case. So that time is both valuable for the attorney and is also valuable for their staff, but especially for the individual client who's never gone through that type of process before. Secondly, the time value of money. You can make money on the money, and most Qualified Settlement Fund administrators are going to be able to develop a proposal based on the amount of assets and the time curation, etc. You don't want to create a conflict for your QSF administrator to have an incentive to tie up the money or move slowly. That's an important practice tip. But at the same time, even if you safely park the money with a prominent bank and you're on balance sheet, or you are in treasury or government agency money market type of assets, so that there's no risk of principal, you're in this current environment, even at 0 interest rates, you're going to be able to get 1.2, maybe 1.4% on that money, and that can pay for the QSF administrator. It can pay for lien resolution fees. It can go towards any other expense of distribution, or it can go to the client as interest earned. And in significant cases, if you have complexities before distribution is going to be a reality, that interest over 90 to 120 days can be hundreds of thousands of dollars. We just recently had a very horrific disfigurement case where the couple was divorcing in New Hampshire, and they had to essentially get an order of the court in New Hampshire last year on the allocation of the proceeds. So we had to park the money, and the client ended up getting a very significant amount of interest. So just for that purpose alone, it can be very valuable. It allows for options to be retained. And so by implementing and creating a qualified settlement fund in your case or in multiple cases or for your firm, you're essentially preserving the right to do comprehensive planning. If you don't need it, don't do it. It's a waste of time if there's no value in it. But most cases these days, they start to get some hair and fuzz on them in one way or another, whether it be Medicare set-aside or lien negotiation. ERISA can be very complicated. So those issues really are difficult to start before settlement because you don't have a number from which to negotiate. Benefits, you're getting rid of the defendant and their attorney. And so if you start thinking about all of the things that civil justice has done for the last few decades in terms of planning, a lot of it's involved defendants in getting their cooperation. Not necessary. If you want to defer your fee, it's none of their business. And if you rely on a qualified settlement fund, then you're working with a friendly third-party administrator that looks to you as the client, has a fiduciary obligation over the settlement proceeds, obviously, but it's someone that you're choosing to work with. And you can outsource to the extent that you want distribution management, and really load up that qualified settlement fund administrator with the duties that you may not want. And in this virtual world, with people working from home, if productivity is an issue, in a similar hundreds of Depakote cases this last few months, we were able to do distributions with the instructions directly from the law firm, and we were able to get payments out to families expeditiously in almost 44, 45 states. And so had the law firm been doing that, it may have taken them a lot longer. So qualified settlement funds are by nature familiar with banking and checks and clearing and processing. So that's an important feature. It's an important thing to go into mediation, understanding, and let your mediator know if you've already got a qualified settlement fund established. It should be a term of settlement. In your mediation statement, it should say that it's going to be payable to, the consideration will be payable to the XYZ qualified settlement fund. And so that there's no questions about, whether the defense lawyer knew or understood what it is that you were talking about. Because there's a lot of misinformation about qualified settlement funds and their uses. And the last thing you want is to get a binding settlement, have a plan to use a QSF, and then the insurer says, well, they have a policy against that, etc. So you definitely want an agreement that includes that. You want the payee of the settlement and the release to be the actual qualified settlement fund itself. By regulation, the entirety of the consideration must be paid to the QSF to extinguish the transferee's liability. And for settlements involving or requiring court approval, is even more important now because you may not be able to get into a court unless there's an emergency session. We're tracking now in all 50 states, what courts are open and not, and under this, COVID blanket, getting things done is can be tough, especially if it requires court approval. But it doesn't mean you can't get the release finalized and collect on the settlement. So things that we think that mediators and defense counsel really need to know is that qualified settlement fund is a legally binding settlement escrow. It's something that you put your signature to as a managing attorney or the lawyer in the case, and it was designed back in the mid 80s to give defendants a complete release. So we hear a lot from our practicing attorneys that we work closely with that defense lawyers are balking at or just putting up some heartburn about, well, I didn't agree to pay to a qualified settlement fund, or I don't know what that is, or I'm never going to pay to one if that's actually how you want to resolve this case. And so having that in your mediation statement, I think, is a good faith effort to resolution. There's no reason, absolutely no reason why a defendant wouldn't want to pay into a qualified settlement fund. It's actually better for them, and it caps all of their contingent liability for everything. Defense lawyers can put whatever language they want in the releases, that you would approve to the additional release, including the use of a qualified settlement fund. We obviously, as administrators, we provide the W-9 and proof of payment back to defense counsel. Many of our engagements also have signators with defense counsel for the defendants in complex cases. That's actually not a preference, but if something that you need to negotiate, it can be a three-party escrow agreement. And a reminder that qualified settlement fund has nothing to do with a structured annuity. And I think a lot of defendants and especially insurance companies, that automatically bring their brokers to mediation. They're two separate things. You reserve the right to have the settlement paid where you want it, and actually, in my opinion, it actually expedites mediation, because then you don't have the broker presenting future value options, etc., which is, in my opinion, annoying. If I were to mediate a case, I wouldn't want them there. Things that mediators should know in advance. They should know what your position is if you want the case paid to a qualified settlement fund, or if you already have one in place and that's your intention, so that they at least know that not only do you want the money, but you also want it paid in that manner. They need to know whether the qualified settlement fund is a deal breaker for you. So if you've had a conversation in advance preparing for settlement with your client, and you've explained qualified settlement fund, and that's how you want the case to resolve, that be something that you share with your neutral in advance. Say, this is important to me, it's important to my client, for all the reasons mentioned. And that the payment to the qualified settlement fund should be in the mediation statement at the end of the day, if you're able to get it resolved. So talking briefly, regardless of your sophistication or familiarity with qualified settlement funds, a lot of people assume that it's just one and done, whether that's a mass tort or not. We take the position that you can have master qualified settlement funds, you can have sub qualified settlement funds in complex inventories and mass torts, and that really gives you a choice of vendor and distribution. So if you're a lead counsel in an MDL, and you're choosing the qualified settlement fund administrator, great. But if you only have 200 or 300 cases, and you don't care to work with the qualified settlement fund administrator, you can carve out your own for your own particular inventory and talk to the coordinating counsel with regard to that. So very at a high level, the types of QSFs that are out there that you can rely upon are a national qualified settlement fund, which is a standing QSF. It's been ordered by a court. Ours, we got set up in 2017. And so the tremendous advantage and value why I think we were invited to this webinar today is solely because if you do want to rely on a qualified settlement fund and you can't get a court order, how do you avail yourself of the benefits of a QSF? We have that standing qualified settlement fund that's available by and through an adjournment agreement. Also quickly have, you can establish a qualified settlement fund for just your law firm. It can be the Smith Qualified Settlement Fund account, or you name it anything you want, but Essentially the logic and the operation of the qualified settlement fund allows you to settle any case in inventory throughout the year into that one qualified settlement fund, and so that you're not going back to court for every single case. And that's very attractive and can be priced competitively. And you, of course, can get qualified settlement fund established and ordered for an individual case or an inventory of cases, which means going to the courthouse and that. And to talk a little bit about the choice of jurisdiction, I think it's a misunderstood point. You really do have freedom of choice of jurisdiction. It doesn't have to be where the lawsuit is indexed. It can be in a property or a probate or surrogate court, because you're essentially creating a trust and getting a tax ID. It can be a sub-entity of the government, like a county clerk. And so the regulations are very free form with regard to where you choose to create your qualified settlement fund, and it not be directly tied to where you've been litigating the case. Just an example of what our joiner agreement looks like. And essentially that you recognize that if it's a pre-existing qualified settlement fund, you still have to meet all the requirements. It has to meet claim type. You have to have segregation of the assets from the transferor, et cetera, et cetera. I mean, so proofing this up is very easy. Skip this. For the firm level, you create the qualified settlement fund for your intended purposes and for your clients to benefit for the vehicle throughout the year. You can settle 5, 10, 15 cases into it. And of course, you can do the individual case, which we mentioned. Quick timeline on using qualified settlement funds. It's a planning phase. There's nothing wrong with getting it set up before you mediate the case. Going back to Peter's comment, being prepared is that you sweat in training, so to speak, and bleed in war. It's important that if you intend to use it, you can get it set up and planned ahead of time. Talking to a good close friend, Bruce Braley, many of you know, he's an advocate for the use of these and getting them established ahead of time. And it's just all part of essentially greasing the skids and being prepared for the end of litigation. But quickly, establishing your fund if you're not joining a national. Knowing what the defendant's position. It's very difficult to use a qualified settlement fund in DOJ cases. It's very difficult with a handful of insurers that essentially, because of their annuity steering practices, really detest the use of qualified settlement fund. But in that logic, you'll see that in creating one, you're preserving your client's rights, which we think is important. Things to expect from a qualified settlement fund administrator. They're a private banker. They can involve CPAs and give you complex accounting, which is important. And in complex cases, that's fundamental. There should be, a 3 to 5 day average turnaround or request for distribution, so money can flow quickly. So when you choose your QSF administrator, take into account the size of their team, how much money they have on deposit, how busy are they, and if they literally have tens of thousands of cases, how attentive will their staff be to your law firm? And that's a business relationship that's very fundamental and dynamic and important. And I mentioned this already, I'm running a little bit late on time, but the biggest benefit to your clients is time. It allows for them to consider all their options without getting into settlement planning, whether it be a special needs trust or some other type of tax structure. You've captured or preserved the ability to do all those things. Biggest benefit to the law firms out there, and this is probably the most important thing I'll say all day, is that a qualified settlement fund really allows you as a managing partner of a firm to manage your cash flows from one year to the next. If you're settling a case in October, can that be 2020 money or is that 2021 money? And a qualified settlement fund perfectly allows you to manage that year to year, and that's a huge revenue planning feature. And you leave the door open to defer. So wherever you are in your practice, if you've never considered doing an attorney fee deferral, it's an unlimited ability to defer taxes on an unlimited amount of income or revenue. It's one of the biggest planning tools that a plaintiff lawyer has So if you want to leave the door open for that, using a qualified settlement fund will certainly give you the right to do that. And I'll bring it to a close. Thank you very much, and everybody stay safe out there.
Thank you so much.